Thank you for your patience. We will now move on to the Ministry of Justice part, and let us begin the panel discussion. The theme is sharing experiences on the enforcement of intellectual property right infringement cases in ASEAN countries and Japan. Now let me introduce our panelists. Mr. Kozo Yabe, attorney at law, partner at Mido Suji LPC, Tokyo office. Mr. Rui Higuchi, instructor, Japan Institute of Criminal Justice and Criminology International Cooperation Department, Ministry of Justice. Mr. Ayu Yokogoshi, Deputy Director, Office of Intellectual Property Rights, Customs Clearance Division, Customs and Tariff Bureau, Ministry of Finance. Ms. Caleb Parida, Attorney Office of the Deputy Commissioner, Intelligence Group Bureau of Customs, Philippines. Mr. Kansako Indrasawat, Section Director Enforcement Division, Royal Thai Customs. Mr. Romanderas Manurum, IP Investigator, Legal Analyst, Directorate Law Enforcement, Directorate General of Intellectual Property, Ministry of Law of Republic Indonesia. Today he joins online. Mr. Shamsul Nizam bin Halil, Deputy Director General of Enforcement, Ministry of Domestic Trade and Cost of Living, Malaysia. Mr. Vignesh Baren, Counsel Allen and Guido Hill LLP, Singapore. And we will hold a panel discussion with these panelists. Thank you for your cooperation.
Good afternoon, everyone. I am Kozo Yabe, serving as the moderator today alongside Mr. Rui Higuchi from the Ministry of Justice. In front of distinguished guests and the participants from the floor or the online, it is a great honor to serve as a moderator for this session of the Judicial Symposium on Intellectual Property, commemorating the 20th anniversary of the establishment of the International Property High Court in Japan. Although this session will span 2 hours, I sincerely ask for your kind attention and cooperation throughout. In addition, I would very appreciate it if you could understand all English speaking in this session for speakers. As previously introduced, today's overall the speakers have been presented. In Symposium 1, we will hear about border enforcement measures focusing on customs practices in Japan, the Philippines, and Thailand in that order. In Symposium 2, we will explore various countermeasures against intellectual property infringement on the internet with presentations from Indonesia, Malaysia, and Singapore. Due to time constraints, Symposiums 1 and 2 will proceed without a break, followed by the discussion session at the end. We regret to inform you that due to limited time, we will not be able to take questions from the floor or online participants. This discussion will be conducted solely among the moderator and speakers, and we appreciate your understanding in this matter. Before we hear about the experiences of each country, I would like to briefly outline the Japanese government's policy on countermeasures against pirated contents on the internet. Additionally, I will briefly introduce Japan's approach to holding online platform providers accountable in the context of the e-commerce. I hope this will serve as a starting point for the comparing systems across countries. As you are aware, the rapid expansion of the commercial and expressive activities on the internet has led to the increasingly serious cases of intellectual property infringement. In Japan, particularly in the content industry, we have long struggled with countermeasures against overseas piracy. Since 2019, the Japanese government has formulated comprehensive countermeasures menus. Countermeasures menu, which is updated as needed, this menu consists of 3 main points. The first measures to deter users' access to pirated contents. And second, enforcement efforts against operators of the pirated sites, with copyright infringement being an especially urgent issue. And third, efforts to dismantle the negative ecosystem by severing connections with private services that distribute pirated content. I will not go into the detail on the 3 points of the comprehensive countermeasures menu, but they are briefly summarized in my slides 4 to 6, which I invite you to review. Recent notable initiatives include public awareness campaigns following the 2020 amendments to the Copyright Act. The Act made downloaded infringing content illegally and created the measures against reach site and link site. In addition, the 2021 major revision of Providers Liability Limitation Act simplified and expedited the procedure for disclosing sender information related to intellectual property infringement. The concept of the platform provider responsibility has also become clearer. This law, now referred to as Information Distribution Platform Regulation Act, is introduced in my slide 8. But furthermore, the Japanese government is promoting a mutual understanding between rights holder and telecommunications providers through joint meetings. These efforts aim to facilitate information sharing about piracy sites and promote countermeasures against business that facilitates the distribution of pirated content. And finally, regarding the pursuit of the responsibility for intellectual property infringement by online platform providers in Japan, as shown in my slide 7, I would like to touch on the basic principles established in Japanese law, Japanese case law. In post-Japanese copyright infringement cases, courts have tended to determine whether a platform provider can be considered a de facto infringer based on factors such as their selection of infringing contents and the nature and extent of their involvement. This approach is sometimes referred to as the normative entity theory. In contrast, trademark infringement cases have emphasized the platform provider's responsibility to manage illegal activities by sellers on e-commerce sites. In the notable IP trademark cases of the IP High Court, the platform provider's failure to take appropriate action against trademark infringement on its site was cited as a ground for granting injunctions and damages against the provider itself. Based on such case law, the current Information Distribution Platform Regulation Act stipulates that if a platform provider knew or had reasonable grounds to know of intellectual property infringement, and if it is possible to take measures to prevent the transmission of infringing information to unspecified persons, the provider may be held liable for damages. That concludes the introduction of this session.